Good morning and welcome to this special session for the Court of Appeals on August 6th of 2025. My name is Leslie Isherwood. I am your presiding judge for today, which essentially just means I'm your glorified timekeeper. I have asked Judge Pickering to be a backup timekeeper as my Zoom can be persnickety, and I was kicked off of my last oral argument. I'm not exactly sure what that says, but we'll roll with it. Joining me today are Judge Kim Schroeder, who's been with our court since 2013, and Judge Rachel Pickering, who joined our court in 2022. I would ask the parties if you would prefer rebuttal time, that you make us aware of that at the time you announce your appearance. And with that, I would call the case 127090 in the matter of the marriage of Madeline and John Kenkel. Would the parties announce their appearances, please?
May it please the court, Joseph Booth appears on behalf of the appellant John Kenkel, and I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted. Thank you, Mr. Booth.
May it please the court, Your Honor, Colby Rickey appears on behalf of the appellee Madeline Kenkel. Just in case, I'd also like to reserve 5 minutes for rebuttal.
You actually don't have rebuttal time?
Oh, that's true. Sorry, sorry. Yeah.
I'd give it to you if I could.
Sorry, that's right. I don't know. Thanks.
You're fine. Okay, Mr. Booth, if you're ready to proceed, you may go ahead.
I am. Thank you for the consideration to be allowed to present this by Zoom. It does help the parties considerably. This is a case in which it was a very short-term marriage. In fact, the parties...
let me ask you a quick question, counsel.
Sure.
This case is an abuse of discretion.
Yes.
So I assume you're going to address where the abuse occurred?
Sure.
And if you're worried about expenses for the parties, why don't you guys just settle it?
Oh, okay.
Well,
I'm not being...
no, abuse of discretion is a high burden. Let's get that on the table.
Absolutely. The issue here is you can tell whether or not a decision is arbitrary by going through the decision and seeing what the judge considered, and exactly how the judge parsed out the division of assets. Here, we don't really know how. That's the largest issue before this court. The abuse of discretion really has to do with the fact that even after 2 requests to explain where the math came from and how the mechanisms for distribution were supposed to work, we still didn't get any kind of understanding of what is going on. For example, we really don't know what the judge gauged the size of the marital estate to be. If you look at the difference of opinions between the parties, there's a fairly vast difference.
Well, then I have another question.
Sure.
You guys knew exactly what the assets of this marriage were. It's basically stocks and various investment accounts and checking account balances. Why didn't you permit or submit to the court a joint exhibit on what the exact assets were and then on that exhibit show what you requested for your client and what the respondent requested, or the petitioner?
The closest we came to that were 2 competing different spreadsheet type presentations that evolved as we knew we were heading towards trial. We did not do a joint. Some of the judges request one to be all on one sheet. We follow the style of having just the competing spreadsheets, each leaning off the other. There were large areas in which we had very similar opinions, and it dealt with an awful lot of the smaller stuff. We had very similar feelings as far as the number of shares of stock at various points. We argued about the respective values. So when we talk about shares of stock on one hand, we're also talking about how to quantify that value on the other hand. And so that's where the differences lie. And instead of having it side by side, it was 2 spreadsheets setting, if the judge chose to, laying out on the bench, one versus the other. Does that answer your question, Your Honor?
Yeah, I mean, I tried lots of divorces in the past. I never proceeded with a divorce on property that was at issue without a joint exhibit. It just made life so much easier for everybody.
It may have,
Proceed.
it may have in this situation, we had so many different spreadsheets that were talking in various theories, and we had a dramatically different approach between the two parties as to how to value this, especially the Garmin stock. Mr. York's approach, which was a long-term view over what the increase would be, and took into serious account the fact that at the date of marriage, we had an artificially low value per share of stock, which would have meant that if you take into account the purchase price, John would have been underwater and would have suffered a loss. And instead of considering it in that way, Mr. York took a longer view. Mr. Barbridge took what I would consider to be a more traditional view, and just took the strike price of the stock on the date of marriage and subtracted it from the strike price as of the date of valuation, which is commonly done. But you know, it has its own issues. The judge eventually chose and favored Barbridge's style, but not his conclusions. So we were so different in the approach that it would have made that kind of side-by-side kind of comparison a little more difficult to see, because it wasn't just, I believe the farm is worth X and somebody else believes the farm's worth X times 2. It was a different methodological approach that underlaid it that was more of the issue. So going back to your first question, Your Honor, not having an ability to really tell how to quantify what happened. We have very few knowns. One thing that we do know is John had a net value of 1.6 million as of the date of marriage. That's a finding of the court that was never disturbed, and accounted for. The judge made that decision in his first decision, and that was never changed in any way. We argue that part of the decision is law of the case. But at that point, then we get into variables such as when and how, the amount of money versus the amount of shares. We don't know what the judge used as far as the growth in coming to the share calculation. We have a jump between a dollar amount as far as the in number, and the out number is a share amount. And we don't know what the basis was to understand what that distribution would be. Then we're left with an order that says transfer 4,000 shares of Garmin stock through a QDRO, but QDROs don't work that way. If we're going to divide a 401k type account, we're going to wind up having to, it's going to be divided by percentages or a dollar amount. The plan administrator, in my experience, doesn't generally just look at the shares of specific elements.
Have either one of you contacted the plan administrator to determine what form they require?
I did not, and I didn't see anything in the record. And as far as we argued, let me put it this way. My client argued that he did informally in the record. He said, and it was part of one of our motions to reconsider, that the courts, that they're going to give a cash distribution, not a share distribution. The share distribution isn't as troublesome in and of itself, because of the way the tax implications are. There's no basis, and there's no growth in a 401k as we would have held in traditional accounts. But that splinters out immediately, because significant holdings of Garmin stock were also outside of a 401k. So we have our Garmin stocks being held in a larger bucket than what is within the Quadro, and then converting it to the Quadro, that skips or runs a risk of skipping the amount that was invested in what the basis is, as well as the tax implications for selling the stock and any other ramification that would be different from the Quadro.
My understanding in looking at the accounting is that there's more than 4,000 shares outside of the Quadro.
That's true.
So if he transferred 4,000 shares to her as a result of a property division, she would just pick up the basis that he had in those shares.
I think that was the original contemplation. When the court says the parties preferred a share distribution, that was a conversation about what would be held in what I would call traditional brokerage holdings, not within a tax deferred plan, because that was significant with both experts tackling the issue of the basis and what that growth would be in the cost of sale and what kind of impact that would have. It would also have
But the 4,000 shares, if your client transfers them to her, then he has no tax liability, and she assumes it when she converts it to cash.
Correct. If he transferred shares outside of the 401k, but the order says do it by Quadro.
I thought the order said he could pick what stocks to do.
That's the 175,000, or at least it's ambiguous in what it says, but it says, let's see, it's in the decision that came down. Sorry, I'm looking at a separate. Let me get to the record on appeal. The order says he can distribute that I think it's roughly 175,000 in any way he sees fit.
Right.
So that part is ambiguous in the sense of what's he supposed to do as to when to strike 175,000.
It's the date of valuation. Why is that not clear?
Because it doesn't say so. I mean,
But
you have to assume
you
the
guys
date.
agreed that the valuations were set on the date of valuation. So that has to be the number that the court used.
If it's the 175 and if it's the date of valuation, then he's to transfer at any point in time the 175,000. If that's the reading of it, that would resolve the $175,000 question on the mechanics of that. He could transfer shares of stock or cash equivalents in any combination.
At the time of valuation.
If the order's read in that way, yes.
Well, how can we read it any other way, counsel? If you guys agreed upon a valuation date, and those are the numbers that you provided to the court when it divided it.
Well, I would argue that we're extrapolating what we think should be read there, but we have an order that is now months after, or years after the date of valuation, basically, that says give her $175,000 as of the date of the order. So that we have an inherent contradiction there. And when we tried to clear that up in their two motions for clarify the findings to 252, and of course the motion to alter or amend would go with that, just as how do you get there. We tried to resolve that issue and didn't get any clarity. On the first motion to alter or amend, there were a number of adjustments being made, including, I believe that's where that comment made he can transfer in any way he wants. And then on the second, of course, was just a summary denial, as not terribly unexpected when you go for the second motion to alter or amend and for clarity. But we tried, and that's the larger point that I have here, is that we did try.
Mr.
Yes.
Booth, you are getting into your rebuttal time. You are welcome to continue on and waive a portion of that, or you can stop now and maintain your 5 minutes.
I'll stop now unless somebody has a question for me right now.
I have two questions.
Didn't surprise me.
And I had a question, but go ahead, Judge.
All right. It appears to me that the court found that the tax liability that was paid for, I think, tax year 2019 was 16,000. Was it 16,000 for both or just 8,000 for both? And my next question is, it appears that the $15,000 gift to the sister was counted twice because it was not deducted out of the balance in the checking account on the date of valuation because it cleared the bank a few days later. Can you address those two questions?
I'll do them backwards. The sister, yes. His complaint is, yes, he gave the sister money before the date of valuation, but the account balance that was used to determine what that account was did not include that transaction. Very similar to what you said. It didn't clear until afterwards. I don't remember for sure whether we had a first of the month. We had February 29th, so we would have either had a March 1st or a February 1st kind of statement in the record, but it skipped that payment. So then he winds up with a double dip there. My recollection on the $16,000 was it was a total $16,000 for the return, and therefore 8 each. And I see Mr. Ricky nodding. I'm glad to give verification for that. It was not a $32,000 tax bill.
No, I thought it was the court gave 16 and I thought it was 8 from what I looked at. So that's why I'm asking.
I have to just go by my recollection.
Okay.
And
So you're okay with 16,000?
yes,
All right. Thank you.
as the total obligation. Oh, family laws, you tend to cut everything in half, and sometimes you do that 2 or 3 times without knowing.
Well, and that's what your client paid was the 16,000.
Yes, he did the tax return and paid the total taxes.
Thank
I
you.
had a quick question, but I could leave it for rebuttal. If you like, Mr. Booth, or I can just,
Whichever way.
I'm looking at page 47 of your brief. You're asking us to remand. First point is reserve the $1.6 million funding of John's premarital assets, including the treatment of non-premarital portions, the finding that the spouse had a net premarital debt. Is there anything in the order that says the judge did not no longer its ruling no longer took into account the husband's premarital assets of 1.6 million?
The problem is we don't know. When we ask for clarity, we have this declarative statement in the decision that he has 1.6 million as premarital assets. What we don't know is because everything is converted to a different mechanism. We're talking shares, we're talking
Right.
ways in which we have apples and oranges. We simply don't know how and whether he got credit for the 1.6 or some portion thereof.
Okay, thank you.
Okay, you will have 5 minutes rebuttal still, Mr. Booth, since we took your time. Mr. Ricky, we're ready for you whenever you're ready to proceed.
Thank you. May it please the court. Again, my name is Colby Ricky. I represent the wife of Pellee. As counsel stated, this appeal involves the district court's equitable division of marital property, which included the appreciation of publicly traded garment stock that occurred during the marriage and the garment stock that was purchased during the marriage and any appreciation of that stock. Appellee's position is that the court followed Kansas law. It relied on credible expert witness testimony and acted well within the discretion in dividing the appreciated portion of both marital and non-marital assets. The trial court did not abuse its discretion, and the record supports its decision. The court, in appellee's position, we would request not substitute its judgment for that of the district court where the decision was reasonable and supported by evidence. And so, while a different result with respect to the abuse of discretion, why we believe it didn't occur, as the court is aware, a different result might have been possible, but reasonable minds, of course, can differ, but that's not the standard here. And those aren't the grounds for reversal. The question is whether the trial court's ruling was reasonable and supported by the evidence. In this case, appellee believes it was. Pursuant to KSA 232801, the trial court's broad discretion was determined whether or not it was just and reasonable, and whether a property division can't be disturbed absent a clear showing of the court's ruling that it was unreasonable or unsupported by the evidence. In this case, we believe it was reasonable and was supported. Uh,
Counsel, can I ask you a question?
yes, please.
Does it really matter what the value of the estate was at the time they got married when there's no prenuptial agreement?
No, I don't believe so, Judge, because obviously under the law, all property that both parties own at the time that the petition is filed is subject to division by the court. And I will also say it's really important to note that the court is not required to restore any non-marital property to the other party. It is all within the discretion of the court. And the court, I'm sorry, Judge, did I answer your question?
You did,
Okay.
but let me tailor it up with my other question. Do you agree the tax payment was 16,000?
Yes, Judge, I believe that was accurate. I think it was a total
Right.
payment.
And do you agree that the $15,000 gift to the sister was counted twice?
I don't believe it was counted twice. And the other thing I will note is
Well,
that,
the reason I say that is because on your accounting, there's a value for the checking account, and that is before the $15,000 was taken out 3 or 4 days later. And then the court added the $15,000 back. So that's counting it twice as I look at it.
well, if I recall correctly, Judge, I think the statement that I don't think the record and the statement that was provided by husband actually supported that conclusion. If that was the case, I can understand their position. However, I don't believe that it showed that it was double counted and that it was included in one statement and then also subtracted from the account on a subsequent statement. And that's why we took the position that it was not double counted. I hope that makes sense.
Okay. I can look
Okay.
at the record.
Okay.
We can
Thank
look
you.
at the record, I should say.
Sure. Okay. Um, in this case, we believe the division of assets and debts was just and reasonable because the court did consider all the factors under KSA 2328-2. Specifically, the judge stated he reviewed the age, the duration of the marriage, the time, source, and acquisition of the assets, which also included each party's hard work and earnings that they earned during the marriage. And I think particularly important is how they maintained and lived a prudent lifestyle, which allowed all of these assets to accumulate. They chose not to liquidate or sell these holdings. And so they both jointly made a decision, which made this marital property, to hold on to these assets and take advantage of the growth that occurred during the marriage. And so that includes each party's contributions to the marriage, the sacrifices that, for example, the appellee made during the marriage. The parties moved to New Zealand so husband could take a job and further his career, while wife had to actually step away from her career as an associate professor at Benedictine College. And so his growth furthered while hers had to be put on pause. Yes, she did earn an MBA, but she also lost the opportunity, for example, to grow her career and also work towards tenure as an associate professor. The trial court, sitting as the fact finder, is entitled to weigh the credibility of the expert witnesses, and the court specifically chose in this case that the more reliable and conventional methodology was presented by wife's expert. That was clear and specifically stated in the judge's decision and memorandum decision. The decision was reasonable and well within the reasonable outcomes. For example, as you pointed out, there were 11,000 marital shares of garment stock, which the court adopted and was a part of wife's expert witness. Wife requested 50%, which would have been 5,500. However, the court awarded her 4,000 and then awarded husband 7,000. And so we believe, while we don't agree with the outcome, it's certainly within the court's discretion to make that decision. And even if another division was possible, and from appellant standpoint, that he should have received more of those shares, that doesn't mean that this outcome is erroneous. In addition, husband alleges that the court ambiguously awarded wife 4,000 shares and that there was an undefined, formula that was used to determine how she received that amount. However, as the court will recall, an equitable division is not mathematical. It doesn't require that specific formula. It's based on fairness under KSA 232802 and within that court's broad discretion. And furthermore, like I had stated earlier, court is not required to restore husband's non-marital assets. And so in this case, the court wasn't required to restore any of husband's alleged $1.6 million in premarital assets. And to answer Judge Pickering's question, no, there was nowhere in that decision that it stated he did not consider the $1.6 million as a premarital asset. Similarly, I would say it's also not required to assign either party or equalize wife's premarital school loan value to the value of the gift that husband made to his sister for marital funds. The court's discretion, again, with respect to that is broad, and it felt that a fair and equitable outcome was not to restore that entire amount. It doesn't have to specify each and every reason why it came to the conclusion on each and every asset. That discretionary ability is wide and vast. And one of the cases that I had touched on in marriage was in re Marriage of Wells, which is 422 P. 3rd 685. In my brief, it's actually an unpublished opinion from 2018. It was a case that specifically said the same. It's not an abuse of discretion for a trial court to refuse to restore non-marital property to either spouse or give direct credit for gifts acquired during the term of the marriage. It goes on to say it is also within the discretion of the court to include as marital property one party's investment account containing premarital stock. And so this is directly on point, which speaks to the fact that this court made a decision within its authority. With respect to the appellant's position that the findings were insufficient for appellate review, our position is even if the written findings were limited, the record again speaks for itself. There was no prejudice to appellant, and the reviewing is reviewable. The findings were sufficient for appellate review because of the following reasons. The court incorporated wife's detailed expert reports that it adopted as a conventional methodology with respect to the division of assets and debts. This was detailed both in testimony and in the report, and wife requested the same. And so the conclusions and the report and the testimony are all supported in the record. The court was in the best position, as I noted earlier, to weigh each expert's credibility, and the court clearly felt that wife's expert's methodology was strongest and appropriate. We believe there is that ample record support for meaningful appellate review for these reasons. And I think it's also important to note that the court adopted every single one of wife's proposed values on the non-Garmin property also. And so the values that he used and he adopted in his decision came directly from wife's proposed division of assets and debts worksheet. And so it's extremely clear. Each one of these assets and the values thereof, we used a very normal and standard approach. We used the value at the date of the marriage, and we used the value at the date of the stipulated valuation date. Whereas husband changed his values through the trial and even post-trial motions. For example, husband's expert testified to a value early in the day. Later in the day, when husband testified, it was a different value that he was suggesting was both for the Garmin stocks and the non-Garmin shares. There was about a $50,000 difference, and it was $50,000 less. And then when you review his findings of fact and conclusions of law, and also his post-trial motions, the values change again, and they drop another $50,000. So you have a range of $700 and approximately $70,000 all the way down to $669,000. And so the court, in my opinion, clearly felt that not only his methodology was not appropriate and unconventional, but also the values in his testimony as far as what those values weren't credible because his values weren't consistent. whereas the appellee's values remain the same and consistent from the beginning to the end of trial, the post-trial motions, and also appellee's brief. And so, so there were three different values that appellee used throughout this process. I think it's also important to note with respect to husband did receive credit pursuant to wife's expert witness's proposal and also what wife's expert testimony was, that he received credit for the premarital cost basis. And this was done through, it's important to note that both parties proposed that the division of the Garmin shares be done with shares. And so that was agreed upon. And so we agree with the court, and it's exactly what we proposed to the court. And like you had stated, Judge Schroeder, the cost basis will go with the shares that wife is awarded. And exactly what you had noted also, Judge Schroeder, there are more than enough shares that husband can transfer to wife outside of the 401k. The 401k account only holds 1,491 shares. The remaining shares of the 11,000 all remain in brokerage accounts. So a quadro isn't necessary. I agree with you. And so, and that's one of the things that one of the arguments I believe we made also in our post-trial motions and also our appellee brief. And
Let me
so,
ask you, can I ask you a quick question?
yes, sir.
When do you interpret or apply the court's order as effective for the valuation? For when the 175,000 is determined or when the 4,000 shares should be transferred?
Well, I agree with you. It's the date evaluation, the stipulated date evaluation.
So you would just have to go back in time to see what those accounts had and transfer it on that date sometime in February of, was it 19?
February 29th, 2020.
Yeah.
Yes. That's exactly what we would be suggesting, not suggesting, requesting, and we believe that's what also was the court's intention. And there's
Well,
nothing.
do you see any ambiguity in the court's order on that point?
There
As
was
to
a
when,
sorry.
go ahead, no. I won't.
There was a little bit ambiguity. However, when you go back and look at the actual values that were presented at trial, the expert witness's testimony, what petitioner requested at trial, it was what was to be divided equitably because all the non-Garmin shares were divided. The value itself split right down the middle. And so she had requested that it include any gains and losses from the date of valuation to the date of the actual transfer, which is a normal and standard approach that is provided in at least every divorce case that I've been involved in Kansas law and case law supports the same. And so I believe that's correct, Judge, not only for that, but most importantly also for the Garmin shares because there has been a significant increase in value from February 29th, 2020 until the present date. And I believe it would be incredibly inequitably and unfair for her to lose out on that simply because the appellant has filed a brief and didn't agree with the outcome, which under abuse of discretion standard was extremely high to meet with a high burden, and I don't believe they've met that. And so I feel like my client, the appellee, is being significantly punished, not only because of the significant cost she's incurred through all of this, due to the appellant's very unconventional, unstandard, or non-standard approach, which required my client to incur significant fees throughout this process and to suggest and propose a valuation and division that frankly I had never heard of before in 20 years of practice. And obviously the court found that it was not reliable or conventional either. And so we would request that those values make sure that it is today through the date, or sorry, February 29, 2020, through the date of the transfer.
Mr. Ricky, your time has lapsed, but if you would like to take 1 minute to just kind of summarize your position, that would be perfectly fine.
Thank you very much. For all the reasons I stated here today, we believe the court should affirm The district court's decision was equitable, supported by reliable expert testimony, consistent with case law and made within its discretion. The trial court is not required to provide a precise mathematical equation or calculation. It's not required to restore husband's alleged non-marital assets, premarital assets. This court should not substitute its judgment for that of the district court where the decision is reasonable and supported by evidence, which is apparent from the record. In the event that the court remands this matter, wife asserts that the district court should adopt wife's expert calculated cost basis and divide it proportionate to the Garmin shares she receives and any dividends that she would have received had the transfer been made timely. And in the event that this appeal had not been filed, since the decision was, well, since February 29th of 2020, since the date of evaluation. Thank you very much, and I appreciate the time.
Thank you for your argument, counsel. Mr. Booth, you have 5 minutes.
Certainly. The first thing I want to hit on is, and I'm not trying to put words in counsel's mouth, but in answering Judge Schroeder's question, data valuation, Garmin stock, absolutely, we're going to do February 29th. And then later in the conversation, we talk about growth and distributing it, including gains and losses. 208, sorry, tripping over my own tongue. 2802 contemplates awarding gains and losses in defined contribution plans, but not in traditional plans. If we had a quantifiable number for the 4,000 shares, and that was as of the date of valuation, you do a strike price, you figure out what that number is. I believe the legal answer would be judgment interest that would do there. We don't have a statutory provision that automatically grants gains and losses. Our problem rests in the fact that the memorandum decision itself says 4,000 shares will be transferred without any further comment. And then the decision to reconsider says that uses the quadro language. Both parties request stock transfer by quadro. The court previously authorized this method of division. That insinuates that we're using something that a quadro would be applicable for. If we had an exact strike price of the date of valuation and interpreted the order in that way, it would be a very different number, and the calculations would be different. That still does not take into account my client's complaint that at the time of marriage, the stock was artificially low and it would have been underwater, et cetera. But we don't know, because we don't see the math, whether the judge cut the 4,000 shares because of that. We don't know how that rubric worked. So you can use the abuse of discretion standard. Somebody had a question? No, you can use the abuse of discretion standard quite liberally, but it's also fair to say that you could take any decision, because it's so broad, and reverse engineer it and say, well, that's what the judge decided. When parties ask for more clarity and there isn't any more clarity, we're just stonewalled. We don't know whether it was an arbitrary decision. We don't know whether, he had a Ouija ball that numbers from $3,000 to $5,000 and shook it, or what happened.
Well, didn't the court make a finding that there were 11,000 shares of the marriage?
I'm looking at the random decision. The table simply refers to there's Garmin stock, and then there's only 3 pages to the decision. I don't think so. It's just referring to the Garmin stock as an equitable division of the Garmin stock as follows: 4,000 shares to her. It doesn't say we start with this number. I'm looking at both. I'm looking at the decision itself, the 3-page decision, and then the order denying.
Well, isn't it correct that your client had a total of 16,000 shares on the date of valuation?
That sounds about right.
So the court only divided 11.
If it divided something by 50-50, yes. but so it would have said that there was whatever amount was premarital and what, which goes to another question that Your Honor had, and set that aside as part of calculating the 1.6 million. But again, we're left to frankly making up an answer to speculating what that answer would be under the.
I guess I don't mean to hog all the questions, but I'm confused why you're stuck on the premarital valuation of the estate when there was no prenuptial agreement. And when parties get married, all assets of both parties are subject to division by the court in an equitable fashion. Isn't that Kansas law?
I would quibble only in this sense: when the parties file for divorce, then all separate property becomes marital property. Before then, they have separate property under the statutory scheme. So we're here with a divorce action. That is the time when all property is combined. But the court is also called upon in 2802 to consider the time, source, and acquisition. And here we have a definitive finding of 1.6 million in the first decision. We're cleaving to that for a couple of reasons. One, it's important to my client that is the finding that occurred. And the second is that it's the only number when we're talking about this large asset that we have. We go from numbers to shares. And if Your Honor's Judge Schroeder's theory is correct, that the number of shares is valued as of the date of valuation, then we have a number. But we don't have that clearly in the order. If this court interprets it that is the number as of that date of valuation, and that she gets that value, why can't he just write a check for that value? Would be the question. Because
I think your opposing counsel answered that.
Mhm.
Between the date of valuation and today, the Garmin stock is substantially appreciated.
Yes, it has.
And so both parties have. So I don't think it's a matter of when you both agreed to divide shares control, not cash. Does that make sense?
Yes. Well, we still have the ambiguity here of whether we're dividing shares. He says by quadro, which is not workable, as we've discussed, and versus shares in outside of the 401k type plan, 401k and IRA plans.
Does he not have 4,000 shares in his quadro?
I don't think so. I think in this conversation,
That's what Mr. Ricky said he didn't have.
Yeah, I believe, I don't have it in front of me. But I don't believe there's a full 4,000 in the quadro.
Mr. Booth, your time has lapsed. So if you would like to take a moment to wrap up, that would be fine.
Well, can I ask a quick question?
I'm ready, Your Honor.
He has, when you talk about his quadro, are you talking about the T. Rowe Price Garmin retirement plan?
I believe so. It's in a 401k plan, which is the only thing you get the 40 plans are the only ones you get quadros for, if you do a strict reading of what quadro means. I will admit that occasionally IRAs are referred to, courts will say do a quadro for the IRA, which isn't a thing.
All right. Thank you.
It is difficult to drill down to see whether or not my client was unfairly treated when it came to the original price at the start of the marriage, as far as the value being artificially low at the time and his purchase price significantly higher. Those sorts of questions are difficult to ascertain. It's also difficult to ascertain exactly what the court was doing when we've imposed in this conversation the date of valuation of leap year of that year. But there's, as we've talked through this, there's certainly speculation and ambiguities in that. the order is for shares, but then does that leave it to where we have a very different valuation number if we were transferring shares outside of the of a defined benefit plan versus inside of one, or some combination thereof. Any defined deferred benefit plan, sorry, I used the wrong term before. The deferred benefit plan is going to be a transfer of cash because that's the way qualified domestic relations orders work. And my client had proposed that to the court, I believe, in our motion to reconsider. And I think it also came up during the hearing that he had checked and did that. So the problem that we have at this point is we're left to some speculation how to work the order we have and how to understand that the court didn't abuse its discretion. We have a number of mathematical and logical errors that occurred outside that order that bring us to question whether or not everything is shipshape. And we just don't know. Even though we ask, how did you come up with this calculation, and ask twice, we didn't get any further clarity on that point. So we're left with the interest of equitability that is the key guidepost for the court. Really has to have some level of transparency, and in order to analyze whether we feel that there was some abuse of discretion in how the math was done, we'd have to know how the math was done. And of course, abuse of discretion includes the fact that, like the $15,000 to the sister, there's basically a mathematical error. That's classic abuse of discretion. It's not reasonable. And we're left with that. Thank you, Your Honor.
Thank you. Thank you, both counsel. We will take the matter under advisement and issue an opinion as quickly as possible. And
Thank
with
you.
that, the court is in recess.
Thank you very much.